You may have recently heard that there was a major victory on a case involving bump stocks. What you may not have heard is how that case affects you and gun rights moving forward. Hi, I'm Ben, and this is the Minuteman Moment. On January 6, 2023, the full Fifth Circuit bench ruled that a bump stock does not fall under the definition of a machine gun, as set forth in federal law or the National Firearms Act. This means that the court agreed with the pro-gun defendants that ATF lacked the authority to issue the final rule banning bump stocks. So first off, whose case is this? This case is Cargill versus Garland, which is in the Fifth Circuit and was brought forth by local gun store owner and radio host Michael Cargill and the group New Civil Liberties Alliance, with whom GOA has a good working relationship. You may be familiar with a similar case GOA has brought forth, that case being Gun Owners of America versus Garland. Now that case was in the Sixth Circuit and won before a 3-judge panel, but then tied, which is effectively a loss, before the full Sixth Circuit. Late last year, the court was remanded to the lower courts by SCOTUS. So let's tackle the question on everyone's mind following this victory. Are bump stocks legal? Simply put, no they're not. Bump stocks are not legal for anyone just yet. All that's happened so far in the Fifth Circuit Court of Appeals is that they told the judges working throughout the courts in the Fifth Circuit that bump stocks are not machine guns, and that ATF bump stocks rule is not entitled to Chevron deference. These 2 points are equally important, but for different reasons. Now lower courts in the circuit cannot treat a bump stock as a machine gun, and no longer do courts have the power to hide behind Chevron, which is a legal doctrine referencing to the judicial deference given to administrative agencies. Make sense? I didn't think so. Simply put, Chevron deference allows courts to defer to the government agencies on their interpretation of the law, as it's supposed to be their area of expertise. So, using Chevron, courts have deferred to ATF's prior opinion that a bump stock is a machine gun, and allowed to stand that as law. So what happens next? Well, there are 2 options. ATF can either appeal the Fifth Circuit's decision to the Supreme Court by filing what's known as a petition for cert within 90 days. Or, ATF could choose to cut their losses and not appeal, which would be complete chaos. Seriously, there's a lot of pressure for the ATF to appeal, but we'll get back to that in a second. If the ATF appeals to the Supreme Court, this would be a very favorable case for gun owners in the Supreme Court, because you have 13 judges taking the pro-gun position. Now, if ATF doesn't appeal this case, the lower courts must redecide the outcome of the original lawsuit, except this time, they must rule that the bump stocks are not machine guns, and they cannot use the Chevron deference to wiggle out of this situation. Basically, the ATF's lawyers would need to try again, and this time with both their hands behind their backs. Since ATF has no authority to ban bump stocks unless they're actually illegal post-86 machine guns, the only thing in question is, how far will the lower court's judges rule against the ATF's bump stock ban? That ruling could look like a few different things. A judge could normally issue a nationwide injunction against a federal action, but this time, because there's a circuit split with the Sixth Circuit, as I mentioned earlier, a more limited ruling could apply to the whole Fifth Circuit. This means that in some parts of the country, bump stocks are legal, and in some other parts, bump stocks are still illegal machine guns. It doesn't make sense for the ATF to allow this to happen, which is another strong incentive for them to appeal to SCOTUS. A limited ruling could also apply to only one plaintiff, Michael Cargill. If the district court severely limited the outcome of the case to one plaintiff, the ruling could be appealed, or another group, like GOA, could file a new bump stock case and demand a different judge issue a farther-reaching injunction for the whole country or the whole circuit. Alternatively, a group like GOA could demand that everyone represented by the plaintiff, i.e. GOA and our members and our supporters, be enjoined just like Cargill in this scenario. This provides another interesting conundrum for the court. Does this injunction apply to GOA members living in other circuits? Or would it be you must join a gun group to keep your bump stock? Again, this situation provides ATF another strong incentive to appeal the decision to SCOTUS. As we said earlier, this means they would only have 90 days to decide what to do. Next, let's tackle another burning question. What else does this victory protect? Like we said earlier, bump stocks are not legal yet, but this does have some rippling effects that will help gun owners. For starters, the whole bump stock fight was, surprise, never actually about bump stocks. You heard that right. Look, the truth is, you don't need a bump stock to bump fire. I do it all the time with my belt loop. So when the ATF classified bump stocks as machine guns, what they were saying is, anything that could be used to bump fire is a machine gun. So it is critical that the ATF not be allowed to classify bump fire as machine gun fire. Otherwise, ATF could have issued another rule to ban all semi-automatic firearms. Don't believe me? In 2020, it was reported that a judge in Nevada classified AR-15s as machine guns because they were readily convertible to machine guns via a bump stock device. Then again, in 2022, A lawsuit filed by the gun control group Brady alleges that a semi-automatic rifle constitutes a machine gun because it possesses design features which facilitate fully automatic fire by a simple modification or elimination of existing component parts. So the important thing here is that this rule protects the future of all semi-automatic firearms from a presidential gun ban by rogue bureaucrats. That's pretty important. Looking a bit further down the road, this decision may help force reset triggers, some of which have been approved by the ATF, and some of which have not. That whole fight was certainly lost if ATF was able to win in court by declaring the more simple bump fire of a trigger as automatic. So this bodes well for the FRTs. But this also may help on pistol braces. One of the biggest problems we've had with the bump stocks was that judges forcibly gave the government what's called Chevron deference. And this deference helped them avoid ruling on whether a bump stock actually fit the definition of a machine gun. Obviously, it's not a machine gun. So the judges were just using this to skirt the issue and help them ban bump stocks without actually affirming ATF's outrageous interpretation of this statute. Well, the same is true of pistol braces, which the ATF is currently trying to say converts pistols into short-barreled rifles and therefore should be regulated by the National Firearms Act. But the archaic National Firearm Act of 1934 only provides these three criteria. Is the barrel less than 16 inches? Is the overall length less than 26 inches? Is it designed and intended to be fired from the shoulder? These are the only statutory criteria for determining whether a firearm is a short-barreled rifle or a pistol that is under those size criteria, but designed and intended to be fired with one hand, not from the shoulder. Instead, ATF proposed a three-part, multi-factored balancing test based on a bunch of criteria, such as weight, configuration, and modifications, surface area, and these criteria are not found in the National Firearms Act. Now that the Fifth Circuit refused to apply Chevron deference, it looks like a pretty good place to file a pistol brace lawsuit. The Fifth Circuit won't be giving the government deference, and they will rule on whether the ATF can apply all these arbitrary criteria that it made up and that aren't found in statute. Spoiler alert, they don't have the authority. I'm Ben, thanks for watching the Minuteman Moment.